my name is Joe DiBartolomeo. I'm an Oregon personal injury lawyer. I have offices in Astoria, Oregon and Beaverton, Oregon. And in this video, I'm going to talk about how children injury claims in Oregon are unique. There are some special rules that apply when an injured child makes a claim for compensation in Oregon. So let's get started and we'll go through and talk about the differences and things that you should be looking out for. Now, whenever I make a video or write a blog post or an article online about time limits, there's a little bit of hesitation because time limits are, first of all, they change, but also there may be special circumstances in a particular case that make the time limits different, or there may be more than one time limit involved. But I think it's safe to say that by statute in Oregon, a child generally has more time to bring their claim than an adult. And when I say time to bring claim, I'm talking about the time limit to either have the claim resolved by settlement or filed in the appropriate court. Lawyers will often refer to this as the statute of limitations. In the statute itself, I believe it's entitled Limitations on Actions or something similar to that. And the general rule in Oregon is that a child, through an adult representative, has up to 5 years after the injury to have their claim settled by agreement or filed in the appropriate court, or 1 year after the child becomes 18 years old. So it's kind of a two-piece analysis. The 5 years is the maximum amount of time, but it cannot extend more than 1 year beyond the child's 18th birthday. Now, there could be other time limits involved that aren't extended, so to say. So, for example, if the responsible party or the party you're making the claim against is a government agency or government employee, there's a tort claim statute in Oregon. There's also a tort claim statute for claims against federal agencies, and that's a part of federal law. There are special time limits involved with those kinds of claims. They're limits that are placed on giving notice of your intent to make a claim. If there is a claim involving a provider of alcohol, Oregon statute provides that you must give notice within a specific period of time after the injury. Now, there could be special issues involved if you're representing, as an attorney, an injured child, or you're making that claim as a parent on behalf of the injured child. So be aware of other possible time limits. There could be other kinds of claims. I'm talking today about injury claims. And generally, you have 2 years, if you're an adult, from your injury to have your claim filed in court or resolved by settlement. So there are a lot of caveats or qualifications or exceptions or loopholes, but generally, time limits are more liberal for child claims. So let's move on to some other aspects unique to making a claim on behalf of a child in Oregon for a personal injury. So because a child is a child, they don't have the legal ability to file lawsuits in court. The law says that they don't have capacity to do that, and it's really legal capacity. So the way we go about filing a lawsuit on behalf of a child, if it's necessary, is to have somebody appointed as the guardian ad litem. And that's Latin. I don't remember what it stands for, but what it means is some adult has to petition the court at the same time the lawsuit is filed, asking the court to appoint them as a guardian ad litem. And basically what you're doing as the adult is you are filing the lawsuit on behalf of the child. This is usually a formality, it's routine, and when we file cases on behalf of our child clients, we file the petition to appoint the guardian ad litem at the same time. Many times the guardian ad litem is the parent or a parent of the child, but not always. It can be somebody else, but that's something that's different or required when you're filing a lawsuit on behalf of a child. Now, staying on this theme, there are other court oversight issues involved with representing a child. One of those is having a conservatorship opened. A conservatorship is an estate. It's much like if somebody were filing a petition to probate an estate of a deceased individual. It's an estate, and the conservator is the person who is overseeing the conservatorship estate. The protected person is the child. Now, in a claim for personal injury, you're making a claim for compensation, and if the claim resolves or if there's some recovery by going to trial, then that money doesn't go to the child. It has to go into the conservatorship estate. So at one point, the parent or whoever is designated will be petitioning the court to be appointed as a conservator. And that's a whole different kind of proceeding in the court. And there are a lot of different issues involved with being appointed a conservator. When you file that petition, you have to make certain statements, and the overall writing purpose or intent of that, making all these disclosures, is so that the protected person is in fact protected. Stated another way, the court is making sure that the person who is being appointed as a conservator is not going to steal the money from the child. So petitions for conservatorship are always involved in representing children. Now, moving on to that, or moving on from that, let's talk about how this all works when there is some settlement or recovery of the claim. So we've talked about the extended time limits involved with bringing a children's or a child's claim in court. We've talked also about the fact that somebody has to be appointed as a guardian in order to file the claim in court. And then we talked about conservatorship and how a conservatorship is required because at one point there's going to be some recovery, either by settlement or if a case goes to court or trial. Now we're going to talk about how the court oversees the distribution of settlement funds. Now, in this part of the video, I'm assuming that the case has resolved and that there's been some kind of recovery or settlement. Now, in a typical case, what happens, if I'm representing an adult and I settle a case for my client, the insurance company, I'm usually dealing with an insurance company, will send a check to my client trust account. I deposit that check into the trust account, and then from there we disperse the funds. Some of it goes to attorney fees, some of it goes to costs. There may be liens that we have to pay, but eventually, and then we disperse the money to our client. So that money gets paid out of the client trust account. Now, when I represent a child and there is a conservator involved, then we need to petition the court for approval of the settlement. And we have to show the court why we decided to resolve the case, where the money is going to go, and how we believe this is in the best interest of the child. And then the court will review that filing to make sure that the settlement is essentially fair and in the best interest of the child, and the court will decide whether to approve the settlement or not approve the settlement. And oftentimes what we'll do is anybody who is an interested person, and that's a statutory term in the conservatorship statute, gets notice of our petition to approve the settlement, and that includes the child, my client, who is, I believe, over 14 years of age. We can also get everybody to agree that they're not going to object to the settlement and that they're not going to force us to wait the prescribed period of time for objections to be filed. So one way or another, if a case involving an injured child is resolved, the court's going to get to take a look at it, and they're going to either approve or not approve this settlement that is proposed. So let's move on to one more issue that I'd like to cover, and it has to do with how these cases are settled or how settlement funds are managed. All right, now we're kind of moving chronologically through a child's case through the courts, and we talked about the time limits, we talked about how the lawsuit is filed, we talked about getting approval for settlement. Now I want to chat a little bit about the different options involving settlement. Now in the, I don't know if it was the old days or not, but the traditional way that settlement funds are managed is through a conservatorship. And if without anything else involved with the settlement, if a case is resolved for a child and it's approved by the court, the child's money is going to go to a conservatorship. That conservatorship is going to be in an account. It's going to have its own tax identification number. It'll have its own bank account. And those funds are going to be managed by the conservator. And they generally have to be, well, they have to be managed in the best interest of the child. A bonded conservatorship is a conservatorship account that is insured. And what happens is the conservator has to go to an insurance company and get a bond on the conservatorship. And that bond is an insurance policy so that if the conservator steals the money or misappropriates or misspends the money, there's insurance that is there to protect the child. The other thing that is unique to a conservatorship is that every year the conservator has to file an annual report with the court, basically saying, look, here's what I've done with the money. This is the money that's come into the account. This is the money that has gone out of the account. Here are the receipts that verify those expenditures and those deposits. That way the court is overseeing, or it allows the court to oversee the conservatorship, again, with the overriding intent of protecting the child. Now you can have an unbonded, or you can have a conservatorship that doesn't require a bond, but in that kind of a conservatorship, the account that the money is in is restricted. And that means that any money that is spent has to be done with court approval. So in a conservatorship account without a bond that's restricted, every time the conservator wants to make a purchase on behalf of the child, the conservator has to petition the court for approval. And that can be kind of cumbersome, so sometimes we'll like to do a bonded conservatorship to protect the child and allow the conservator to manage the funds in the child's best interest. Now the other option, you still have a conservatorship involved, but the other option is to structure the settlement. And I think it's probably a good time to devote a whole section of this video to structured settlements because it's kind of involved, but let's do that because it is a good option for the child in certain cases. So a structured settlement for a child's claim has a lot of moving parts, but we're going to start out with talking about what I mean by a structured settlement. What I mean when I talk about a structured settlement is taking the settlement funds, it could be some of them, it could be all of them, and basically putting them into an annuity. And then what happens is the money is locked up in that annuity and it grows interest. And then whatever the annuity contract says governs when the money is paid out to the child, but it's always after the child becomes an adult. An annuity is an insurance contract. So what happens when I resolve a case on behalf of a child and we're looking at a structured annuity, I go to an annuity broker who specializes in putting together structured settlements. And then what they do is they give me and my client examples or schedules of how they can structure the annuity payments. So one example might be we structure the settlement so that after my client becomes an adult, maybe goes off to school, college, the payments are made twice a year at a certain amount to help out with college expenses. Or my client might not be college bound, they may go to trade school or they may engage in an apprenticeship, and we would make the scheduled payments correspond to whatever their plan is. we may also hold back a significant portion of the settlement so that it could help in what we anticipate to be the purchase of a first home. Or we may hold out payment of the annuity, so the proceeds in the annuity, so that we know our client, our child client, is at a certain age where they are going to be able to manage these funds in a responsible way. And I always explain to my client, and this is kind of a joke, but I say, hey, if I were the child, we would probably want to delay payment out to age 35 or 40 or something like that, because that's when I finally figured out money management. And it's kind of true with a lot of young adults. They get a large sum of money and they may, decide to spend it on things that maybe they shouldn't have. But whatever, that's the idea behind an annuity, is that you can structure it any way you want. Now, the nice thing about an annuity is that it'll earn interest. So the younger my client is, the more advantage there is in an annuity, in that they're going to recover over the long term much more money to compensate them for their injuries. So that's a real advantage. The other advantage is that the money's locked up, and I kind of touched on that. But also, any interest that is earned is not taxable income to my child client. So if they get a lump sum at age 27 or age 30, and it's a significant amount of money, and a big portion of that is interest that was earned on the annuity, then there are no taxes on that, and that's a great thing. Now, there are a lot of moving parts to these annuity contracts. We want to make sure that the insurance company that is providing the annuity contract is on solid ground financially. We also want to make sure that we do this in a way that preserves the tax-free earnings on the annuity contract. So when we make our request to the court for approval of the settlement, there's specific language that has to be included in the court papers that are filed with the court. The settlement agreement must contain certain language that makes sure that we are preserving the tax-free aspect of the annuity contract. And so we're working with the liability insurance carrier, sometimes my client's own insurance. We're working with the attorney on the other side if they're involved, and we're working with a structured settlement broker. And I also work closely with my client to make sure that the annuity is structured in a way that they are happy with and that they understand and that they approve. So there are a lot of moving parts to this annuity contract, this structured settlement. The other aspect that I like about these settlements is that we can go to the court, and if all of the settlement proceeds are put in an annuity, we can say to the court, look, we don't feel like there's a need to have a bond on this annuity contract. We don't feel there's a need to have annual conservatorship reports, because this money is locked up and the child is protected. So there are a lot of good things about structured settlements, and most of my clients will opt for those. Now, you don't have to put all of the money in a structured settlement. You may be able to leave some of that money in a traditional conservatorship account, which gives you some flexibility. And as I wrap this video up, the other thing to keep in mind is that under Oregon law, if the settlement proceeds to the child are less than $25,000, no court approval is required, no conservatorship is required, and that money can go into an account on behalf of the child with certain stipulations. We have to file an affidavit from the parent or account holder guaranteeing or swearing that the money will not be expended unless there's court approval or until the child becomes an adult. So that's another nice feature of having a hybrid type account where some of it's in the conservatorship account, some of it's in the annuity contract. Okay, so that's a lot of information. I hope it was helpful. I do have a personal injury guide. I'll put a link down below this video where you can download that. I'll also include my contact link so that if you have questions, you can contact us. If you haven't, you can also give us a call. But if you have other questions, you can check out our website. We do have various articles that talk about the unique challenges we face with representing children. We've been doing it for quite a while. Thank you so much for watching this video. I hope it was helpful. Take care.